News at Prime. Let's bring you a different story now. The Health Minister, Dr. Motsoaledi, has welcomed Tiger Brand's decision calling on the families of the victims to come forward with all the medical records to support their claims. The minister joining me this evening to talk more about this particular outcome. Minister, good evening to you and thank you very much for your time. Allow me to take advantage of you having been the recent Minister of Home Affairs. It's not a popular thing that I am forcing you to do here this evening, but I'll take my chances anyway, Minister. You were in the Department of Home Affairs. What is the legal status of, or legal definition rather, of a refugee, and what might be the country's attitude towards the 49 Afrikaners if and when they do decide to come back to the country?
Yeah, Toli, you are right. Good evening to you and the listeners. It's quite exceptional that the minister comments about the department in which he was. But I think I will agree with you. This is an exceptional case. I'm sure you are just asking me as a South African who happen to be having information, and I'll be very glad to help. Look, refugee issues are determined by 3 international conventions. It's the United Nations Convention of 1951, the United Nations Protocol of 1967, and here on the African continent, the Organization of African Unity Convention of 1969. All of them define the conditions under which a person can cross a border or go to another country and claim or demand or request refugee status. Firstly, the things that must happen in that country is that if there is war, you can jump and ask for refugee status. If there's a natural disaster, you can jump or ask for refugee status. Or if you are persecuted in that country, and the convention recognizes 4 types of persecution: political persecution, religious persecution, persecution because of traditional beliefs, and lastly, because of gender or sex outcomes. If you happen to be a lesbian or a gay or what, all those 3, if you are persecuted, 4, if you are persecuted for them, you can go and ask for refugee. Needless to say, none of the things that I've mentioned are applying to these people who went to the United States, who ran there. But if you remember, President Trump doesn't respect any of the laws. He's making his own laws as he legislates, as he moved, as he decides. So all those conventions might not apply to him. But I can tell you, in terms of those conventions, I don't know the U.S. domestic law. In South Africa, we domesticated this convention in the Refugee Act of 1998. And I can tell you, even in terms of that, none of these will qualify. But I don't know the domestic law in the U.S., but I would like to believe that all domestic laws are efficient upon the conventions that I've mentioned.
Yeah.
And none of the conventions will say people like this need any asylum.
Thank you for indulging me, Minister. I'm going to move on quickly, I promise. We now know that if the group that's gone to America become naturalized Americans, that may not necessarily translate to them losing their status as South African citizens as well. But might they have difficulty coming back into the country, given that they went to America under the guise of being refugees?
Yeah, look, these things are new. Obviously, they are going to test the law up to its limit. Once a person is naturalized normally, you become a citizen of that new country. And if you are referring to the Constitutional Court judgment, that Constitutional Court judgment was not talking about refugee. It was specifically talking about a person who moves from South Africa under no cloud, without any complications, go to another country and stay there. Maybe they're waiting for a long time, apply for citizenship, and is granted. The law was trying to make sure that people don't abuse that. The Citizenship Act of 1995 then said, if you ask for that citizenship, you have got to inform the Department of Home Affairs. That's what the government, the Constitutional Court dismissed and say it's unconstitutional. Those are the people that I believe the court case refers to. There were people who went away and asked for refugee status. I am not convinced that that should apply for them, because that's not what went into the Constitutional Court. It was a totally different thing. Even the DA, when they took this issue there, they were talking about South Africans who applied for a citizenship of another country, who inadvertently lose the citizenship of South Africa because of what was written in the law. So I believe the two things are completely different. Now, the issues of coming back, Oli, refugee status is never permanent, or it's not meant to be permanent. If it goes on permanently, I think people get naturalized. The United Nations High Commissioner for Refugee, who's a custodian of all these conventions I've spoken about, can stand up at some stage and announce and say people from such and such a country no longer have any need to stay as refugees because things have normalized. Just to give you a good example, you are aware that there was a war in Angola between MPLA and UNITA.
Yes.
And yes, when the war came to an end, the United Nations announced publicly that people from Angola no longer have any reason to stay in any other country as refugees unless that country allows them to stay so and under a different regime, but not as refugees. And indeed, Angolans were asked to go back. Some opted to go back. Others negotiated to South Africa that we've long been here enough. We're asking to be naturalized. And it was negotiated and it happened like that.
All right.
But the United Nations said, look, nobody must come from Angola to South Africa and come and claim that is a refugee because there's no longer any reason. Now, in South Africa, the United Nations has never even declared South Africa as a refugee or what you sending country. You know that because there is nothing that should make people run away from the country.